Hello everyone. As we all know that in India, if a wife wants to claim a maintenance from the husband, there are various provisions of law where the maintenance can be sought. The first provision is section 24 of Hindu Marriage Act. Second provision is section 23 of the Protection of Women from Domestic Violence Act. Third provision is section 125 of Code of Criminal Procedure, and the fourth provision is section 18 of the Hindu Adoption and Maintenance Act, where a wife can claim maintenance, though under section 24 even a wife or a husband both can claim maintenance. But in today's video, we are going to focus on one particular question, which is generally asked by so many people, that what is the maximum imprisonment a defaulting party has to undergo if there is a default of the order passed under section 24 of Hindu Marriage Act. Before we understand this, we need to understand few basics of law. And the first basic is section 18 of the Family Court Act, which provides that family court is bound to execute the order passed by the family court as provided in Code of Civil Procedure. And this particular point has also been upheld and has been reiterated in the case of Rajneesh versus Neha, which provided that the order of maintenance may be enforced as a money decree of a civil court as given in section 51, 55, 58, 60 and read with order 21 of Civil Procedure Code. The Honorable Delhi High Court recently in the case of Mohit Anand versus Paru Anand has held that if any order is passed under section 24 of Hindu Marriage Act that has to be enforced under section 28 capital A of the Hindu Marriage Act, read with section 18 of Family Court Act and other relevant provisions of CPC. As I have already told you what are the relevant provisions of CPC, we just need to go through section 58 of Civil Procedure Code, which becomes very important here. Section 58 subsection 1 provides that every person detained in the civil prison in execution of a decree shall be so detained where the decree is for the payment of sum of money exceeding 5,000 rupees for a period not exceeding 3 months, and then B provides whether decree is for the payment of sum of money exceeding 2,000 rupees but obviously not more than 5,000 rupees but not exceeding 5,000 rupees for a period of not exceeding 6 weeks. Here one point which we can note is that the maximum period of civil prison which can be given is 3 months if any order is exceeding 5,000 rupees maintenance or decree in this particular case. Then subsection 2 is also relevant here, which provides that a judgment debtor released from detention under this section shall not merely by reason of his release be discharged from his debt, but he shall not be liable to be re-arrested under the decree in execution of which he was detained in the civil prison. So here, second point which we can note is that if a person who has already suffered the incarceration of 3 months in civil prison, then he will not be able to be re-arrested, though the decree holder can enforce the decree or execute the decree through various other modes of execution, but not through arrest. So the same reasoning will fall for section 24 of Hindu Marriage Act. If any order has been passed under this particular section, it means maximum period a person can suffer the incarceration of civil prison is 3 months, and if once he has been released, then he will not be liable to be re-arrested. Please remember that this proposition of law and this reasoning will not be applicable if any order has been passed under section 125 of CRPC, and for that particular provision of 125 CRPC, that what will be the maximum period of incarceration a defaulting party can suffer, we will be covering in the next video. Please remember, one of the most interesting and relevant judgment here is Mohit Anand versus Paru Anand, passed by Delhi High Court, 2024, SCC Online, Delhi 1968. See you tomorrow.